application in the matter of REAP.
Well, good morning.
Yes, good morning, Mr. Bogle.
I appear for the first and second appellants, and there is a application for a third appellant. My learned friend Mr Quintavale appears, and my learned friend Mr Mahmood appears for the Trust Hospital, and Miss Watson Casey appears for the as advocate to the court, effectively, and for the official solicitor.
Thank you. Could I just, before you say any more, just confirm what I think may have been on the tip of your tongue, which is that there are limited reporting restrictions in effect in this case, which is all the parties and probably almost everybody who's present here knows means that the identities of the treating clinicians may not be made public. But so far as I'm aware, there are no other reporting restrictions, in particular in relation to the identity of the trust, the hospital, and in particular their request, I think, the family members may be identified.
That is my understanding, my lord.
Yes.
I see from the nodding heads of my learned friends.
Yes. Well, the order made by the judge had effect until while the proceedings continued. And so, in effect, until we make a final order in this case, that order will remain in effect. If anybody considers that any further formalities need to be applied, they should please say so, but otherwise that's the ground rule.
So what that means, in effect, my lord, is that we have to refer to the clinicians by their initials only.
Yes. Well, I'm not expecting that we're going to need to refer to a great number of them, as it weren't sent by individual names. There are certainly 3 or 4 who are central, but we all know the names by which they are to be referred to.
Indeed, sir, my lord.
Good.
My lord, you should have the permission to appeal bundle, I hope.
We do. Thank you very much, and thank you for preparing it.
And it's divided into 4 parts, A, B, C, and D.
Yes.
There are 2 additions. I don't know if your lordship, if that made its way through. There is an application for a witness statement by all 3 appellants, although the witness statement is by another party. All
right. Well, can I just say that when we were just about to come into court, I think around about 20 past the hour, we became aware that there was some application, and actually we became aware of it by the fact that the trust had suggested that it was going to need to put in some further evidence. Now, we don't know what this is about, and we haven't read anything at all. So apart from knowing what you're about to advance, we haven't investigated that at all. Could I just say one thing before we go further into this? I know that all the lawyers here present, and I suspect many of the other people who are interested in this matter will know that we're not here to carry out a trial in the sense of deciding the issue which was before the judge. That the hearing that has been fixed today is for the specific purpose of considering whether there is any legal error in the order that the judge made. And I know that the submissions that we'll be hearing will be on that question. But I just thought it as well to clear the ground about that. The only point that we're here to consider is whether there's an arguable case in effect that the judge's decision was wrong or unfair.
Indeed.
Now, so far as the other formalities are concerned, there is an application on behalf of Mr. Casey's mother for permission to file an appellant's notice out of time. Unless anybody says anything about that, that will be granted. And I don't think there are any other formalities, save for the matters which you're about to embark upon, that causes the court any concern. We're anxious to hear the family's application on its merits, and not with any procedural hurdles that need to be crossed.
Indeed, my lord. There are 2, as far as the application for additional evidence, which is put in a way that is intended to pass the the necessary tests in that martial and in the CPR. I can either allow.
Well, whose application is it?
It's the application of the three appellants,
Right.
but the evidence has been procured by mother. So I can either defer to my learned friend, Mr.
Well, it's entirely up to yourselves as to who advances this. I'm well able to decide who. We don't want to hear it twice, but
Yeah, right. So either I can do that now, or you can take it, and I'll make reference to it in my submissions. And
no, I think we need to make sure that we have everything that we properly ought to have before we embark upon the argument. And so either make the application or Mr Quintavalli can make it.
I'll defer to my learned friend, Mr. Quintavalli.
Thank you.
Thank you, my lord.
My lord, my lady. The application regards a short witness statement that's been provided to the third appellant by the sister of a man named Lewis Roberts, who's in fact mentioned in my skeleton argument. And Lewis Roberts was 18 a few years ago, 2001. He was diagnosed as being brainstem dead. And the tests were, as I understand it from the witness statement, were carried out no fewer than 7 times because there was objection from the family. And all 7 tests confirmed that Lewis Roberts was in fact brainstem dead. But what then happened is that he, at some stage after this, he started to breathe again. And 2 years later, the recovery is such that he's running around and playing football. And what's significant about this case is that the British Medical Journal, and this is explained in the witness statement, is preparing a piece on this because it's an extraordinary circumstance where someone was declared brainstem dead according to properly apparently carried out brainstem tests as provided by the 2008 code, and yet turned out to be able, contrary to what we're repeatedly told, that this test is 100% accurate, turned out, in fact, to have recovered consciousness and to have now to be able to lead a relatively normal life. And the significance of this goes to the submissions that were made by the official solicitor when I raised in my skeleton argument the fact that in the context of a pediatric case, the courts have found the brainstem test to be unreliable. In fact, there's a revision of the test going on at the moment. And the suggestion was made that as far as adults are concerned, that there's nothing to suggest that it is unreliable. Now, this is precisely very strong evidence to suggest that the tests are unreliable, even in the case of adults. And it's on that basis that this evidence is important to be before the court. As I understand it from the witness statement, the author of the witness statement, having read about the family's plight after the case was publicized, contacted them and wanted to share this information. Obviously, before reporting restrictions were removed at the last hearing, it wasn't possible for people to identify who the family were. And therefore, that's could be an explanation as to why it wasn't possible to get this evidence in.
So what is the date of this statement?
It was dated yesterday.
So 26th of September. How long is it?
It's 2 or 3 pages, and there's an annex, which is a letter from the British Medical Journal confirming that they're publishing this article on.
Yes, and you want us to admit that as fresh evidence?
Yes, and just to be clear, the point that will be made, this is not, the court isn't being called upon to make some sort of in-depth pronouncement on the 2008 code and whether it's accurate or not, but it does go to the submissions on how the court should treat the results of a brainstem test, whether it's as the court below found that the results of the brainstem test have a sort of quasi-statutory implications, or that they effectively confirm death on a legal basis, or whether instead it's simply evidence, as we suggest, maybe very strong evidence, but evidence that someone has died, and the court then has to treat the evidence on that basis. And this shows, this witness statement is important because it shows that these tests, or suggests that these tests are not as reliable as previously thought in the adult context as well as in the pediatric context.
And this, when was this statement served?
It was served, I believe, last night, but I'm not sure about that.
Thank you. And if we were to consider the statement, whether or not we formally admit it, you'll be aware, as we've been made aware a few moments ago, that the Trust wishes to say something in response. What is your position about that?
Well, as I understand it, I had a very quick look just before proceedings started this morning. The essence of the Trust response, but no doubt they'll wish to say more, is that this evidence could have been obtained with without undue rigour. We say that it couldn't for the reasons mentioned about the reporting restrictions that were previously in place.
Yes, well, of course, I don't know what's in the statement that you wish to produce apart from what you've just told us, or in what is in the Trust's response, which presumably has only just been created. But I imagine it may have something to say about the substance of the issue that is raised by the witness statement, and not just.
I'm not sure because I wasn't able to study their response. But perhaps I don't know if any of my learned friends have had a chance to have a look. All I saw in the response is that this is evidence that should have been obtained prior to the
Right. Okay.
last hearing.
Thank you for the moment, Mr. Quintervalli. Anything to add, Ms. Bogle?
No, my lord.
No.
I have some additional copies if anybody needs them, and I'm sure your lordship will.
Thank you. Can I come to you, Mr. Mahmood? You, I think, have sent a message to the court saying that you have something that you would wish it to consider if it considered the witness statement referred to. Firstly, what is your position in relation to the court seeing de bene esse, in other words, for practical purposes, what the statement consists of? Leave aside the question of whether it ought to be formally admitted for the moment, but also in relation to any response that you say.
My Lord, my Lady, first of all, may I once again express the deepest sympathies to Mr. Andy Casey's family and friends, and it's appropriate I do that from the outset. May I then respond to my learned friends' applications in relation to the admission of fresh evidence? On this de bene esse, this provisional basis, I see no objection why my Lord, my Lady should not.
Right, so we understand what we're talking about.
Yes.
It's very difficult for us as judges to make sense of this without knowing what it is that the parties know. There are tests, and they're quite important tests, as to whether or not the evidence is formally admitted.
Yes.
But quite commonly, and this seems to me to be the approach that you're at least not opposing,
Yes.
We look at it in order to see what it consists of before
Yes.
going any further. So that you don't object to.
My Lord, correct.
As we do that, what is it that you want us to look at in response from your trust?
My Lord, so the very brief chronology is that the statement from Mrs. Roberts was sent late last night. My learned friend is correct, and it was just into late last night because it was about 11:30
Yes.
p.m. before midnight. And I'm afraid I and those who instruct me didn't see that until this morning.
No.
That's a statement. In addition, a letter from Mr Bogle has provided a further email with a request or explanation from a Dr Brown, a proposed expert, who received that this morning at 7:45
Right.
a.m.
Well, Dr. Brown and that we are aware of.
Yes. And so what we respectfully say is, in relation to the application, that it requires a response from the local authority. And I was in the fortunate position that Dr S was able to very quickly look at.
Right. So what have you?
He has
got?
provided a short witness statement.
How long?
2 pages. Sorry, 2.5 pages.
And has that been shared with the other parties?
Yes, it has.
I don't see it.
Right.
It's been emailed to everybody, I should say, so it's been shared in that respect. Yes.
Well, you'd like us, if we look at the first statement, to look at that as well.
Yes. I should say there's a third aspect to the evidence. There's a video which has been taken by the family, and that's part of the application as well. And that is something that Dr S responds to in his witness statement as well. So there's 3 aspects. Firstly, the statement from Mrs Roberts. Secondly, the video that the family have taken. And thirdly, Dr Brown. And Dr S responds to the video and Mrs Roberts' statement, and I respond to Dr Brown's email.
Right. Now, thank you, Mr. Novid.
Thank you.
Mr. Quintavalli, do you have any objection to us seeing paper versions of Ms. Roberts' statement and the responses to those various matters from the Trust?
No, certainly not, my lord.
Right.
I would like to see a paper copy myself of the...
Yes. Well, what I think, subject to my lady's views, what I think we'll do is we'll rise for about a quarter of an hour or something like this, so that people are not under undue pressure and have an opportunity to take any instructions that are necessary. In order to look at these materials ourselves, we're not going to start looking at videos. If the time comes where that was to become appropriate, we would need to have another discussion. But we'll take what we can from the written material, and let's see, we'll return at 10 to 11 by the.
Well, it's already 10 to 11.
Sorry, I beg your pardon. The court clock is traditionally out. Yes. So we'll return at say 5 past. Mr.
rise if able.
My Lord, if I may, sorry, just respond briefly to my learned friend, Mr Mahmood. Dealing with the simplest matter first, the email from Mr Brown is simply to confirm what is already in the bundle
Yes.
at tab A211, page A272, which is the scope of what he proposes to do. That note that is in there is prepared by me, as having been communicated by Dr. Brown. This is simply to confirm that.
Yes.
So it seems
Well, it didn't seem to us that
why it's controversial.
it led to any further argument.
No. So that's that. But as far as the evidence and the objection to the witness statement and the video is concerned, in my submission, it emphasises the need for second opinion evidence on behalf of the family, because otherwise it's simply the family's lay view and that of Miss Jade Roberts in her witness statement versus that of a medical expert. And there's simply no equality of answer.
Can I say what we're inclined to do about this? We've now grasped the matters that you want to put before us. We've grasped what the trust wants to say about that. So we have the information. We propose to leave matters in that state for the moment, that when we come to make our ruling, we'll make some formal ruling as to whether and what we formally might admit. But for the moment, as it were, you can proceed with your application on the basis that we're up to speed with what it is that you'd like us to be aware of. So I don't propose that we should make any formal ruling about this at this stage.
Very good, my lord.
And also, I should say, for the reassurance of your clients, that we've carefully read what is said about the video, but at all events, we're not going to look at the video because it wouldn't make any sense, in a sense, for us to look at one video when there are another 30 videos. So that we have clearly in mind what it's said to show and what comment is made in response. So that's where matters will rest in relation to the video, whatever else may happen.
Will it assist the court to know what Dr. Brown's initial reaction was?
No.
Okay.
No, because we've taken to this point, and there has to come a point where we actually get on and consider the application.
Very good, my lord. Well, then I shall move to the application, if I may, my lord.
Thank you.
My lord and my lady, I'll just refer to my lord inclusively. The treating clinicians concluded that AC was brainstem dead, but the family, as you know, contest the conclusion, stating that AC is still showing signs of life incompatible with the diagnosis of brainstem death, e.g., as per the video, movement in response to a request by the family. The claim form of the trust, dated the 18th of August 2023, sought declarations and orders that it is lawful for ventilation or other medical care to be withdrawn, and sought the appointment of the official solicitor as a litigation friend, which in due course Mr Justice Moore did. In my submission, that tends to indicate that at that stage at least a best interest hearing was intended. And by the order of Mr Justice Moore, dated the 23rd of August, AC was joined as a party, remains a party, and the official solicitor was appointed conditionally as litigation friend, subject of course to her agreement and consent, or otherwise. And that was to be indicated in a position statement which was duly filed before Mr Justice MacDonald. In that position statement, at the hearing on the 12th of September before MacDonald J, the OS by counsel declined the invitation to act as litigation friend, effectively on the basis that AC was already dead, and that he therefore need not be a party to the proceedings. That the final hearing before MacDonald J was merely, to quote from the official solicitor's own skeleton argument before Mr Justice MacDonald, discreet and procedural, and that the court should simply make a declaration of death predicated upon the earlier conclusion of the medical witnesses of the trust. Given the OS declining to act as a litigation friend, AAC never, in fact, had a litigation friend and therefore remained unrepresented since he was made a party by Mr Justice Morton. For the reasons stated in their evidence, the first and second appellants opposed the Part 8 application of the Trust and sought permission to be joined in proceedings or permission for a second opinion medical report. But at that stage, it being short notice, they were unable to locate and find and provide names and details of a relevant expert. And on that basis, largely, but not exclusively, permission was refused by the court. Since then, they have found a neurointensivist who's willing to examine the patient and provide a report. Now, there seems, from the beginning of the case, to have been some procedural confusion in the case management of the case. Not blaming anybody, but we must simply look at the facts head on. Both Mr Justice Moore and Mr Justice Peel treated the patient as still alive and as a party who, being mentally incapacitated, required under Civil Procedure Rule 21.3 a litigation friend. The appointment by Mr Justice Moore of the OS, conditionally as we saw, was, in my submission, of doubtful provenance, given that the OS had not yet been consulted and, as it transpired, declined to be appointed, therefore making the appointment, in my submission, void from the beginning. The result was that AC was unrepresented, despite being a party who required representation under CPR 21.3 sub 2, which reads, Your Lordship will know, forgive me if I repeat it, a person may not, without the court's permission, make an application against a child or protected party before proceedings has started, or B, take any step in proceedings except issuing and serving a claim form or applying for the appointment of a litigation friend under Rule 21.6 until the child or protected party has a litigation friend. And furthermore, under CPR 21.3.4, any step taken before a child or protected party has a litigation friend has no effect unless the court orders otherwise. Accordingly, on the face of it, at any rate, all steps taken after Mr Justice Moore appointed AC a party appear to have been a nullity and of no effect. I shall deal with this more fully when I come to that particular ground. Taking the grounds at each stage, ground one, as to that,
could I just attempt to make sure in a case where there are two sets of grounds of appeal that we have a series of propositions that we can label and focus on so everybody knows what argument we're talking about. Having looked at the helpful paperwork that you've both filed, it seems to me that there are 5 issues for us, and if I may, I'll tell you what I think they are so that you can amend them, or because in the end you must, within the limits of procedure, be able to argue the case as you think fit. But it seems to me that in logical order the 5 issues are this. Firstly, that you argue that the trial wasn't fair because the judge refused to allow the family to instruct another expert. Secondly, that the proceedings were not fair because Mr Casey wasn't represented by a litigation friend, the point that you've just been touching on. Thirdly, that the judge was wrong in law to treat brainstem death as a legal test for death. Fourthly, that he was wrong in law to use the civil standard of proof when making a finding of death. And fifth, that he was wrong in law not to have carried out a best interests assessment. I appreciate that each of these, as it were, there are particular arguments that you deploy in support of those matters, but for your part, are you content that that, as it were, is the menu of arguments that you are collectively advancing?
Yes, my lord.
I'm not...
Unless I've overlooked something, yes.
Well, unless you encounter something in your presentation that makes you think otherwise, is that a reasonable starting point?
It is indeed, my lord.
Mr Quintavalli.
Yes, we're pursuing 2, 3 and 4 only, as far as our appeal is concerned.
Right, so that your not. Do you have a position in relation to the 1st and the 5th? Are you supporting them, or are you not adopting them?
I'm certainly supporting the first.
Yes.
The fifth, I wait to hear what my learned friend has to say.
All right. But broadly speaking, for our working purposes, you're happy that we have those 5 points so that we can identify what we're talking about. Thank you very much.
So, my lord, ground one effectively goes to your lordship's issue 1, unfair trial, Article 6.1, and partially, I suppose, Article 2, issue 2. We put it this way: since issue was joined precisely because members of the family of AC objected to the diagnosis of brainstem death, a second opinion medical report commissioned by them was, in my submission, a logical corollary to the proceedings. And on that basis alone, and it's not the only basis we submit, was reasonably required for the court to resolve the issue before it, pursuant to CPR 35.1.
Yes.
Moreover, importantly in my submission, the official solicitor did not object so long as sufficient detail was provided in advance. And Dr. S, indeed, in his witness statement, his second witness statement, had indicated that he and the Trust ordinarily welcomed second opinion evidence. Indeed, during the submissions, counsel for the OS said that she would have, quote unquote, absolutely have endorsed the request, but for the lack of detail. And therefore, because of the lack of detail, she objected. Those details, as I've said, couldn't be obtained in the short time available, but given the lapse of time, have now been obtained, and you've seen and heard and read something about Dr. Jules Brown. In my submission, my lord, it was wrong in principle to refuse permission for the appellants to adduce their own second opinion evidence, and the decision for that reason, or for the reasons I'm going to advance, was more than an ordinary case management decision. Indeed, as I say, this matter would not have come before the court but for the opposition of the family to the evidence and conclusions of the Trust and its commissions. There simply wouldn't have been a hearing otherwise. Accordingly, any such expert evidence in support of the family's position was clearly central to the issue before the court, i.e., is AC dead? Given that such expert evidence was essential and necessary for the family to be able, in any clinically meaningful way, to put their case, it submitted that it was more than reasonably required, it was necessary. Without it, the appellants were deprived of the expert material upon which they would be enabled to put a full case to the Trust witnesses. Instead, and without it, they were only able, in effect, to rely upon such knowledge as they, as lay people, and their counsel had, neither of whom, of course, are medical experts, let alone experts in neurointensivism. And in my submission, that was unfair, and it was unfair to deprive them of their own second opinion expert and to leave them to rely solely upon their own knowledge and that of counsel to cross-examine medical experts, the Trust witnesses. It was, in effect, to tie their hands by refusing them access to the necessary, as I submit, clinical expertise that they required, by expert evidence, to be able to challenge the evidence of the Trust's expert witnesses in anything other than a necessarily incomplete manner. And in my submission, therefore, the learned judge erred in refusing it. Time should have been allowed, not much time, granted, for the obtaining of such a report. And, as we've seen, now the time has elapsed, a relevant second opinion neurointensivist has been found who is willing and able to produce the necessary report. There is a further, in my submission, equally pressing point. And if I may refer to the evidence of Miss Roberts, de Benesi, and in the light, perhaps more relevantly, the case of Guy's and St Thomas's NHS Foundation Trust against A, which is a 2022 case, EWHC 1873, and is to be found in the authorities bundle, your lordship knows it well, at page 469. There is some doubt in my submission about the reliability of current brainstem death testing. And as we saw in that, as as de bene esse one can see in the Roberts case, the failure was stark and radical, the patient having made apparently a full recovery and indeed is now playing sport. But in the case of A, it was also radical. Now that was a child, admittedly, but the child had been effectively had undergone the brainstem death testing, and if the case had accelerated at a faster pace, might have the ventilation and life support might have been withdrawn with fatal consequences. But the child began to breathe, and the hospital, to be fair to them, immediately restored the life support and brought the case back to court. And in addition to that, and I apprehend that this is not controversial, it may be that this is not as a result of the case of A, but it is nonetheless the case that the code is being reviewed as a consequence of uncertainty. Whether it is as a consequence of the erroneous diagnosis of death by neurological criteria in the case of A is immaterial. The fact is it is being reviewed, not just for children, but for adults. In the A case, A met the criteria for brainstem death, was declared dead on the 19th of June 2022, following 2 tests by 3 specialist doctors. But A attempted to breathe and was later judged not dead, according to the court, Mr Justice Hayden. If matters had, as I say, proceeded to court at a more rapid rate, and under the mistaken assumption that the patient was already dead, did not need to be a party, therefore, and did not need representation or a litigation friend, the court might well have made an erroneous and premature declaration of death with fatal consequences for a living person, namely A.
Do you want to say anything about the evidence which I have read was in front of the judge, although I don't think I've read what it was that was in front of the judge, about communication with the chair of the reviewing committee and any relevance to this case of that review? Do you want to deal with that?
You mean the shortness of the time frame?
No,
Or just the fact that there was communication?
Well, there was communication, and as I understand it was reported to the judge that the view of the chair of the committee was that what they were reviewing was not relevant to what we are concerned with.
Oh, I see.
Here.
I see.
I just want to give you the opportunity to deal with that, or indeed to check whether that is in fact a correct account of what the judge understood.
Yeah, I don't know whether that is in fact what happened, although that is a submission made by my learned friends. And
well, if it's only a submission, then we're not going to take any notice of it.
No.
But if in fact the judge received evidence that actually the review doesn't bear upon this, and I can't at the moment put my hand on where I read this.
My lord,
my
may
learned friend
I-
is standing
I'm
up,
sorry.
but she will have an opportunity to put that and address that matter in due course.
In order
I'd
to allow
like
my
to get
learned
on with
friend
my
to do
submission.
so,
Just a moment, Ms. Bow.
in order to allow my learned friend to do so, may I just indicate that the evidence referred to is at C222
All right.
of the bundle.
Thank you.
What we
So
say
it's only to say that if you want to say anything about that, please do.
I shall.
Thank you.
Yeah, all I say about that is, this is what is being put to your lordship here is that the brainstem test criteria there's an element of uncertainty there that is now being recognised by the relevant medical committee, such that they are reviewing the code in relation to adults, as I understand it, particularly in relation to the apnea test, but other tests as well, and that degree of uncertainty is relevant to this case, regardless of whether the chairman of the committee considers that it was or not. And in addition to that, the chairman of that committee, Dr. Dale Gardner, himself was not a treating clinician of
Dr.
AC.
E. for the
I believe it was
purposes of
Dr.
this
Gardner
case.
who we're talking about, but I may be wrong.
He's anonymised. That's my reason for intervening.
I'm sorry, my fault entirely, my lord. He's not a treating. He may not be subject to the RRO because he's not a treating clinician.
No.
He's well known to be chairman of that
That's
committee.
why I mentioned.
And he is not an expert in this case. So that opinion must have, at the very most, very limited value.
Right. That's the submission. I understand it.
Yeah,
Thank you.
thank you, my lord. So what happened is that counsel for the official solicitor in her skeleton asserts that there is no urgent reassessment of the criteria for the diagnosis of death in the case of adults in the light of Ray A. Well, that may be so. The fact is, as I say, there is a review in respect of adults.
But Mr Bogle, in relation to that,
to a solicitor. He complained of interference with his Article 6 right, unsurprisingly, to a fair trial and public determination of his civil rights and obligations, but faced the difficulty that without legal assistance, he had been unable to initiate a proceeding in which his fair trial right could attach. The issue was the existence of a corollary ancillary right to make effective the substantive right. Despite this apparent hurdle, his application succeeded, and the European Court of Human Rights held at paragraphs 34 to 36 as follows, and I'll cite it if I may. It's at page 873 to 5 of the authorities bundle. Paragraph 34, and in civil matters one can scarcely conceive of the rule of law without there being a possibility of having access to the courts. Paragraph 35, it would be inconceivable in the opinion of the court that Article 6.1 should describe in detail the procedural guarantees afforded to parties in a pending lawsuit and should not first protect that which alone makes it in fact possible to benefit from such guarantees. That is, access to a court. The fair, public and expeditious characteristics of judicial proceedings are of no value at all if there are no judicial proceedings. And then at paragraph 36, taking all the preceding considerations together, it follows that the right of access constitutes an element which is inherent in the rights stated by Article 6.1. This is not an extensive interpretation forcing new obligations on the contracting states. It is based on the very terms of the first sentence of Article 6.1, read in its context and having regard to the object and purpose of the Convention, a law-making treaty. And he refers, the court then refers to the Wemhoff judgment and to general principles of law. The court thus reaches the conclusion without needing to resort to supplementary means of interpretation as envisaged by Article 32 of the Vienna Convention, that Article 6.1 secures to everyone the right to have any claim relating to his civil rights, any claim, and obligations brought before a court or tribunal. In this way, the article embodies the right to a court, of which the right of access, that is, the right to institute proceedings before courts in civil matters, constitutes one aspect only. Now, it might be said, it's all rather trite, that is a fairly obvious consideration in English law, but it has nonetheless to be said that there is this authority to support that principle in the European jurisdiction. So the European Court of Human Rights thus held that the Article 6 needed to be interpreted in its context and having regard to the object and purpose of the Convention, and the process that makes it possible to commence judicial proceedings, such as instructions of a lawyer, is protected by necessary implication. By analogy, if Article 6 includes access to legal assistance, it also includes access to legal representation at a hearing, which it is submitted in this case is denied to AC because he hasn't any representation at all, by a litigation friend, by counsel, or at all. In the case, another European case, the case of Multiplex against Croatia, that's at page 918 of the authorities bundle, and the facts are set out at page 920 to 922. The court held that a right of access to a court must be practical and effective.
I think these are fairly well-known general principles. I mean, can we descend to
take it as read.
The particulars of this case?
So, in addition, if I could just briefly refer to another case, the case of SC against the United Kingdom, and that's to be found at page 928 of the bundle, the authorities bundle. The facts are stated at page 928 as well. For a right to be practical and effective, access to the court must take account of the intellectual abilities of the individual. And in that case, the applicant had reduced intellectual ability, and the court held that there was an obligation on the state to ensure that he was represented, particularly in view of his reduced intellectual capacity. So, in short, without representation by a litigation friend, AC appears to have been denied his fundamental Article 6 rights. Now, moving on to the issue of best interests assessment, which is your Lordship's issue 5. As I said already, the Part 8 application had the character of a best interest application, ostensibly, for the OS to be appointed litigation friend and for permission to withdraw treatment on the basis that it was not in the patient's best interest. And it seems that Mr Justice Morse treated in that way. Indeed, it's my submission that that is to be the preferred approach to be taken in such cases, notwithstanding that there have been declaration of death approach taken in a number of first instance cases, no doubt about that.
Well, I think it's probably common ground, isn't it, that if somebody is not alive, if somebody is dead, then the question of best interest does not arise.
There's no question about that.
No question about that.
The real question is...
Because I understand you have arguments in relation to how death is to be understood. But
we do.
But if somebody is not alive, then best interest doesn't arise.
Yes.
Right. What is your submission? That, as I understand it, it's that until the court has finally concluded that somebody is not alive, it must make a best interest assessment.
That's what we say, yes.
Yes.
Yes. And indeed, that is the approach that was adopted in the case of Barts Health NHS Trust against Dance.
Yes.
Battersby in 2022, EWCA Civ 935, which is at page 428 of the authorities bundle. And in my submission, that is the approach to be preferred, albeit there had been no brainstem test in that case. Nonetheless, the procedure that was adopted in my submission is the right one.
So what should the judge have done in this case?
Yes, that's what I invited.
What should the judge have done in this case?
That's what I invited Mr Justice MacDonald to treat it as a best interest hearing and then conclude whether or not the treatment should be withdrawn. Then he didn't have to get into it.
What were you asking him to do? Not to consider the question of whether Mr Casey was alive, but instead to consider what was in his best interest.
Yes, on the basis that he was a party, albeit unrepresented. And therefore the assumption was that he was still alive.
Right. So I'm just teasing out exactly what this amounts to. Your case was that the court was obliged to assume that Mr Casey was alive, to assess his best interests, and then, having done so, to reach a conclusion as to A, whether he was or was not alive, and if he was, what was in his best interest.
Yes. But I'm not saying he was obliged. He could, because it had been done in other first instance cases, have made a declaration of death. What I'm saying is, first of all, there needed to be evidence from the family.
Yes.
That's my arguments that I've already made before he could arrive at that conclusion. What I'm saying is that the better approach is to adopt the best interest approach. And then if the treatment that's being provided is not in the patient's best interest, it can be withdrawn, regardless of whether the patient is declared dead or not. But it as it were, assists the court in avoiding the complicated issue of what is and is not death. And that's another issue which we'll come on to in a moment.
Right, so just so I haven't misunderstood this, you would say, and I appreciate these very important matters, that in a case of this kind, you say that it is always the better approach for the court to assess best interests, even if it then concludes that they're not determinative because the person is unfortunately not alive.
Well, I'm not going to say in every case or always, but I'm saying.
But if not in this case.
In this case, yes, that would have been a better approach, particularly as AC was a party. Right. And if he's a party, the assumption is no higher than that he's alive.
Yeah, but whereas you'll appreciate, not dealing with what the judge might have done or might not have done, we're only concerned with whether what the judge did was lawful, and
I'd say not.
For that, your submission would have to be that he was obliged to assess best interests.
In this case, yes. But as far as all such cases, and particularly looking at the case, as I will in a moment, of Ray M, no, not necessarily in all cases. But in this case, yes.
And so that I understand you, in this case, because AC was a party,
yes.
And therefore you say the assumption accordingly is that he is alive.
Yes. Yes. And if I'm wrong about that, at the very least, rebutting medical evidence should have been permitted to the family so that they could contest the medical evidence fairly and on a level playing field. And then either argue best interest or the declaration of death on the basis of their own medical evidence, at the very least. So, in my submission, the authority of Ray M, which is much relied upon by my learned friends, and of course also importantly by the judge, that's the 2020 case EWCA Civ 164 at page 374 of the authorities bundle, does not bind the court. Given that it was a refusal of permission to appeal, and that pursuant to the Supreme Court Practice Direction of 2001 to be found at the first volume of the Weekly Law Reports, page 1, page 947 in the authorities bundle, it did not, in my submission, attempt clearly to establish a new principle or to extend the present law, which is the requirement stipulated at paragraph 6.1 and 6.2 of the practice submission, but merely set out a recommended procedure to be followed. Moreover, it didn't give any indication that took the form of an express statement to that effect, as required by the practice direction. Indeed, one would not expect that a decision refusing permission to appeal would at the same time establish a new principle or extend the present law, since that might have the consequence of unfairly blocking the aggrieved litigant from challenging the new principle or extension by further appeal or by further seeking permission to appeal, there being no appeal against the refusal of permission. In my submission, that would be unfair and unjust to the aggrieved litigant. The proper place to refuse permission and exclude further appeals would be at the next appellate level, it being contrary to principle, in my submission, for a court, when establishing a new principle or extending the law, to allow any obstacle to be placed in the way of a litigant seeking to appeal against its own decision, and particularly not by, as it were, such a merely procedural expedient. In my submission, that would be wrong in principle. Therefore, it must be taken, I submit, that the practice direction does not intend such a departure from principle. Moreover, it is perhaps an open question as to the extent to which I hesitate to use the word mere practice direction when it's coming from the Supreme Court, but a practice direction alone can be said to vitiate or compromise the long-established common law relating to precedent and the principle of stare decisis. The latter being a principle established by the usual operation of the common law through decisions in particular cases with particular sets of facts, not merely a rule of procedure or a practice direction. It is, in my submission, to be presumed that the Supreme Court did not intend that long-established common law principles established in case law, based upon actual facts, should be overturned by a directive, in effect, that is normally intended only to deal chiefly with procedural matters and the efficient running of the courts. The common law develops by case, as it is applied to a particular set of facts in particular judgments, all by Parliament, and not, in my submission, by general directives decoupled from particular sets of facts. It must therefore be presumed, in my submission, that the Court did not intend such a departure by mere directive or practice direction from the normal development of the common law doctrine of stare decisis. In any event, as already submitted, the case of Ray M did not purport to lay down new principles or extend the law, but only to recommend a particular procedure. Furthermore, it is submitted that the procedure recommended can produce, as here, contradictions. The question of whether or not AC was dead, or is dead, so that treatment may be withdrawn, was before the court to be determined by the court, not by anyone else. The court ought, therefore, in my submission, not to treat the patient as already adjudged dead, and thus to be excluded as a party, with no need for a litigation friend, when that was the very gravamen of the issue before the court. To do so seems to beg the very question at issue before the court, and to consider prejudged and predetermined, and that extrajudicially, the very issue that fell to be determined by the court. In my submission, it cannot, as a matter of principle, be right for the court to consider itself in effect restrained or constrained and restricted by the decision of a witness, albeit an expert medical witness or series of witnesses, as if that decision were akin to a judicial decision. Nor can the court, as it were, outsource a decision that is at the very heart of the proceedings, namely whether or not the patient is dead, to a witness or to witnesses, when that is the very gravamen of the issue that the court itself needs to decide. That is an issue which ultimately must be determined by the court and not a witness extrajudicially. Nevertheless, if, as the OS argued before the court below, The court's task is discrete and merely procedural and consists only in verifying that the witnesses, in concluding that the patient is dead, have followed the 2008 code, now of course under review by the AMRC, then the real decision in my submission as to death has not in fact been taken by the court, but effectively by witnesses. The court merely does no more than confirm that the code has been followed in so arriving at that conclusion, a conclusion which preempts that of the court because the patient is not made a party. That must be the logical conclusion of not making the patient a party, i.e. that it has been prejudged and predetermined that he is dead. And that, of course, was the position of the OS, and as I understand it, remains the OS's position. To consider that the court is merely engaging in a discrete procedural issue in declaring death is, in my submission, to put the cart before the horse, and to do so in a matter of the very gravest moment, i.e. whether or not the patient is dead, a matter at the very heart of the case. How, therefore, I ask, can the central gravamen of the case be effectively outsourced to a witness? The witness is, in effect, usurping the role of the court, save to the extent that the court must decide whether or not the code has been followed. And the court would be doing so without the patient, the central subject matter of the case, being represented. Because, as I say, he, being considered dead, was presumably not considered necessary to be represented or to have a litigation represented, or, as in the case of Ray M., not to be made a party at all. In my submission, that seems to beg the very question at issue. And, furthermore, it creates even greater unfairness for the respondent family, in my submission. In effect, I submit, the burden of proof is reversed so that the family are obliged to prove that the patient is not dead, rather than for the trust and the clinicians to prove that the patient is, in fact, dead. And once again, this is to put the cart before the horse. The trust is the claimant. It must prove its case, not the other way round, i.e. that the respondent must disprove the claimant's case. Worse still, in my submission, the family is at an even greater disadvantage. If it is expected to disprove the trust's case, and to do so without permission to adduce any expert evidence of its own, the respondent family are, in my submission, thereby at a double disadvantage, the burden of proof being reversed, and they not being permitted to adduce any expert evidence to rebut the expert evidence of the trust. They've not only had their hands tied behind their back, but they're also blindfolded before being sent into the ring. My submission, that's clearly unfair and is a breach of their Article 1 rights under the Convention to a Fair Trial. Reversal of the burden of proof onto a respondent is, in my submission, already unfair, but it is made doubly so by refusing permission for them, now unfairly burdened with disproving the claimant's case, to an expert of their own to challenge the expert evidence of the claimant trust. Now, to argue, as the OS does, that following Ray M, best interest is not relevant in determining whether the supposedly narrow issue of whether or not the patient is dead is once again to beg the issue, or the question at issue. If best interests are irrelevant, then the decision as to whether or not the patient is dead has in fact already been made, even before the court comes to determine it for itself, since the very basis for saying the patient has no best interest is that he's dead. But, as I say, that is the very issue.
Well, I think you've put that point in a number of ways.
And so the argument as to whether or not the patient is dead becomes circular. Moreover, in my submission, the respondent is unfairly prejudiced in having to argue against what is virtually a fait accompli. And that is why I submit that the refusal to give permission to the appellants to adduce their own expert evidence is very much more than a case management decision that goes to the very heart of the matter before the court, namely whether or not AC is dead, and severely prejudices the respondent family because, as I say, they're not able to challenge the evidence of trust on a like-for-like basis, expert against expert. The playing field is not level, and there's no equality of arms. And this is all the more prejudicial if the burden of proof has been shifted. And that, in my submission, is also a reason for submitting that the approach adopted in Battersby and Dance remains preferable, even where a brainstem death test has been carried out. Because adjudicating if and when death occurs is a question that cannot be reduced merely to a medical or legal issue, however convenient that may be. And that is why, in my submission, the better approach is to have recourse to the more familiar territory of best interests, and on that basis to determine whether or not the treatment concerned should or should not be withdrawn or withheld, and particularly in this case, where AC was already a party. In my submission, the court was obliged to go down that route. That then avoids the complex question and issue of when and where death occurs, and reaches a proper conclusion by a more familiar route, a route that is not only familiar to the court but also to the OS.
But you say it avoids the issue of when death has occurred, but that's not an issue that can be avoided.
Well, if you have a best interest hearing, it's effectively avoided, isn't it?
So, well,
because you don't have to get into the issue of whether he's dead or not, just whether or not the treatment is in his best interest to be continued. And in many circumstances, the treatment will not be in his best interest.
In deciding that, one would inevitably have to know whether somebody was alive.
Not necessarily.
And if they were not alive, when they had died.
Not necessarily.
I see.
If we take the case of Airedale NHS Trust against Bland, nobody was in any doubt that Tony Bland was still alive.
No, that's right.
But the treatment was withdrawn.
It was a different case. That was a PVS case.
But the treatment was withdrawn. Yes. It was deemed not to be in his best interest.
I understand that. Okay, but anyhow, you
Without
say the issue of when somebody has died can and should be avoided.
Very good. Yes.
But Mr. Bogle, in these circumstances, is it not circular? Because you conduct a best interests investigation, but as soon as you do so in this case, immediately pops up, well, it can't be in his best interests because he's not alive.
Certainly.
So you do have to address the very question of whether he's alive or not, because best interests, in a very amateur, broad brush way, if I look at it that way, one is going to be thinking, is it right to continue doing X or Y to this person? And the answer is going to depend on whether there is going to be any good outcome, put it that way, from doing these things, which inevitably is going to lead you right back round your circle to whether he's dead or alive, surely. So, even if you've done the taken the best interest route, you'd have arrived at the same place. You'd have had to decide in relation to whether it was best interests to continue to ventilate, for example, what his state was, putting it neutrally. So are they not, in this case at least, entirely bound up with each other?
They don't need to be, my lady.
Not even here?
Not even here.
Okay.
Because it goes without saying that it's pointless to ventilate a corpse. If he is actually dead, then there is clearly no point, and you don't need to get into the issue of best interest, in continuing the treatment. But if there's doubt about that, you have the option, and in my submission, it's the better course to follow, and should have been followed by the judge, to go for a best interest hearing. Because in both cases, treatment can be withdrawn. If it's not in the patient's best interest, it can be withdrawn. If the patient is dead, it can be withdrawn. It doesn't follow that you must make a finding that the patient is dead in order to withdraw the treatment.
So you say, even in these circumstances, there is a window in which one can a door which one can go through, which means that you can decide that it's not in the best interests of this particular patient to continue to ventilate him in the circumstances that it's in, doubt whether he is dead or alive, but his condition is so severely affected. So you
Exactly.
say you do avoid the dead or alive issue.
Exactly.
Okay.
And to avoid getting into an area which, by I think all are agreed, is controversial and need not trouble the court to get involved in issues that are controversial, are liable to have ramifications the court may not foresee at the time, whereas the more familiar best interest course, it doesn't have that problem.
I understand, thank you.
And I might add that that there are going to be cases, and perhaps this is one I don't submit one way or the other, which are far worse, or at least worse, than the case of Bland. And in Bland's case, treatment was deemed not to be in his best interest. So if there are cases that are worse than Bland, you still don't need to determine whether the patient is dead or not in order to ensure that treatment was withdrawn on the best interest criteria.
I understand, thank you.
Thank you, my lady. I won't cite from the case of Dance, Battersby's, Your Lordship and your Ladyship will, I'm sure, be very familiar with it, except to say that to refer the court to paragraph 43 of that judgment, again at page 428 of the authorities bundle, at page 435, where the court says that whilst understanding the difficult position that the Guardian, the Guardian is analogous to the OS here, was placed in, having herself concluded that Archie was dead beyond doubt, it was ultimately for the court to determine whether or not to make a declaration of death. At all stages prior to a declaration of death being made, Archie remained a party to the proceedings, and his children's guardian, here in this case OS, retained the duties placed upon her by the family procedure rules, and was in addition subject to the duties of the practice direction to advise the court on the options available to the court with respect to the child and the suitability of each such option, including what order should be made in determining the application. Unless the court otherwise directs, the children's guardian must file a report advising on the best interests of the child. And in future cases, says the court, this court, in future cases, even where a children's guardian apprehends that the medical evidence may establish that the represented child has died, the guardian should discharge their continuing duty to advise the court on best interests unless and until a declaration of death has been made. Now, the difference here is, of course, that the OS isn't obliged to become a litigation friend. But a litigation friend should have been in a position that is occupied effectively by the guardian in that case, and particularly as AC was still a party to the proceeding, should have continued that role on the assumption that AC was alive because he was a party. And it is submitted that that is not only the better approach in all cases, but that in this case it should have been done that way. As I say, without repeating myself unduly, it means that the real and effective decision as to whether or not the patient is dead has already been made. And that cannot be the right approach. Accordingly, in my submission, the office of the OS should not be one merely of advocate to the court, helpful though that clearly is, but in her usual role, she should be discharging her duty like that of the guardian in Dance and Battersby to advise the court on best interest of the patient who is yet to be declared dead and must therefore be still alive, if of course she consents to do so. Mr Justice MacDonald distinguished this case on the basis that it had not been possible to conduct a brainstem test therein, but it submitted that that does not vitiate the approach taken in Dance, particularly in the light of the case of A before Mr Justice Hayden, and the ongoing review of the code, and the clear circularity of the approach, in my submission, circularity, recommended in Ray A. Moreover, as already submitted, in such an important case as the determination of death, a further medical report was and is clearly required, whether or not the court decides to go down the best interest route or the declaration of death route. And moving on to, therefore, the question of the whole status of the proceeding, which
can you give us some indication of where you've reached?
I am about 10 minutes away
means.
Thank you, my lord. In addition, the question of the whole status of proceedings must be considered. Once again, Mr Justice Moore made AC a party. He attempted to appoint the OS as solicitor. That failed. Accordingly, AC has no litigation friend. On the face of it, then, the consequence of AC not having a litigation friend was to vitiate the proceedings in their entirety. Since, save with the permission of the court, CPR 2134, no step may be taken until a litigation friend is appointed. Since AC remained a party, and since the appointment of the OS was voided by her refusal to consent, AC had no litigation friend, wasn't represented, and therefore, pursuant to CPR 2134, no step could be taken after he was made a party by Mr Justice Moore. All such steps as were taken thus appear to be a nullity. The Trust has argued that by paragraph 60...
Sorry, and where does that fit in with the grounds of appeal? You just say that's a consequence of the second issue that my lord iterated, which is trial was not fair because no litigation friend.
Precisely, and I want to address it to assist the court.
Okay.
Paragraph 60.
Paragraph 60 and 81 of the judgment, the Trust argues, that the court validated the proceedings retroactively by giving permission for the patient to be a party without a litigation friend. I pause to say that that does not appear in the amended order, although my recollection is that there was a paragraph to that effect in the original order, and it may have escaped the judge's attention.
Well, I was trying to hunt this down, so let's just look at this. You wanted to start at paragraph 60.
Paragraph 60, my lord, yes.
I found the last sentence rather difficult to unpick.
I'm rehearsing the Trust's argument here. Your Lordship appreciates.
Paragraph 60. Are we at the same point?
Where Mr Justice MacDonald says, in the foregoing context...
Yes, we don't need to read it out, but that's the paragraph to which you refer.
It's the paragraph that the Trust
Yes.
is referring to, and I'm going to address their argument thereon.
Yes. Well, what we have here is the judge grappling with the point that you're making
Yes.
about the fact that another judge had appointed, had joined Mr Casey, and had ordered, in fact, inappropriately, the official solicitor to represent him, because you can't order the official solicitor to do that. But there's no doubt from paragraph 60 that the judge was alert to the fact that Mr Casey, though a party, was unrepresented.
Yes.
And his order did not, as one might have expected it to do, discharge Mr Casey as a party.
Yes. Indeed.
Is that what appeared but in a draft but didn't then turn up in the final version?
No, I think what he said, as I recall, it was paragraph 3, he said that AC was a party notwithstanding that he had no litigation friend.
Right. And so, in effect, the judge considered that he was waiving the absence of a litigation friend.
Yes.
Right.
And that's what he says in paragraph 81, more or less, although I believe there was a later clarification in correspondence between the Trust and the judge, in which he said there was no application to discharge AC as a party, therefore I didn't discharge.
Right. So it's he is deploying 21.3 sub 4 to make his decision in the absence of a litigation friend for Mr Casey. Yes. Yes. So that's 81.
Yes, but he's doing it retroactively, and that's the problem part, as it were. So the court retroactively gives permission for the patient to be a party without a...
Well, it doesn't really matter whether he's done it in his judgment or at the beginning of the case. I mean,
Yes, well,
he clearly heard the case on the basis that that was what he was going to do. Otherwise, he would have stopped and got a litigation friend.
Yeah,
so it doesn't matter.
It does seem to be so, but nonetheless, there is this problem of retroactivity. One asks the question, as it were, academically, can a set of proceedings that are invalid before they even start be validated retroactively?
Right, so that's the question that you raised.
Yeah. The order is invalid, therefore, even before it is made. a litigation friend had to be appointed before any step, including the proceedings themselves, could be taken. Thus, the proceedings in which the order of retroactivity was made were invalid even before the order was made. Well, it seems that in certain circumstances, an order retroactively validating a failure to appoint a litigation friend can be made. But it can only be made when there is no prejudice suffered by any party. And I refer your Lordship to the case of Masterman Lister against Bruton and Co. 2003, first volume of the Weekly Law Reports, page 1511, which is at page 189 of the authority bundle, and also the Court of Appeal case of Dunhill against Bergen, 2014. Sorry, it's a Supreme Court case.
Yes.
UKSC 18, first volume of the Weekly Law Reports for 2014, 933, and that is at page 326 of the authorities bundle. Now, in my submission, there is still an issue as to correcting the failure to appoint a litigation friend in circumstances where the very proceedings in which you're supposed to make that order have not been invalidated, versus a situation where that doesn't occur. So that's still problem number one. But in any case, it must be the most serious kind of prejudice, in my submission, for a party whose very living existence is in question, and who is a party to the proceedings, let us not forget, and therefore still presumed to be living, to be deprived of representation, even assuming that an order can be made retroactively in proceedings that were a nullity even before they started, if you see what I'm saying. Simply put, a party cannot be treated as dead unless and until a court has declared it so. And until that time, he must be presumed to be alive, must be made a party, must be represented by a litigation friend, and the proceedings themselves are potentially vitiated if that hasn't happened. My Lord, I will, to save time, leave submissions in relation to issues 3 and 4 to my learned friend Mr Quintavale, and then if I can at a later stage, if I agree, adopt his submissions, and just simply move on to my last point, which is the expression raised by Mrs Justice Leven in the Nadik case of anxious scrutiny. It's further, or indeed, I suppose technically in the alternative submitted, that the court failed to apply the correct test of anxious or heightened scrutiny, even if the court got the correct standard of proof, which my learned friend is going to argue it did not. Nonetheless, failing to apply that standard of anxious heightened scrutiny resulted in a failure to satisfy the requirements of Article 6 per grounds 1, 2 and 3 above. Whether this meant the court should have applied the criminal standard or the civil standard, it is submitted the court nonetheless erred. The learned judge accordingly failed adequately to address the standard of proof, did not apply the necessary heightened level of scrutiny, and this, in my submission, was particularly characterised, certainly augmented by his refusal of permission for a further second opinion medical report. It submitted that there could not be anxious scrutiny, to use the expression of Mrs Justice Leven, which she has adopted from various other authorities, including European authorities, of the evidence. If evidence that was reasonably required, indeed necessary in my submission, to do justice to the position of the respondent family, was not permitted to be put before the court. It's not enough to engage in anxious scrutiny of only the evidence that was before the court. Anxious scrutiny in my submission must also entail ensuring that all the evidence that was reasonably required was before the court, so as to do justice to the position of the respondent family, and indeed to AC himself, especially where, as I've submitted earlier, there was a reversal of the burden of proof, and where, absent second opinion evidence adduced by the family, there wouldn't be a level playing field and no scope for them to be able to challenge expert evidence from the trust, they having none of their own. And as regards that issue, my submission is that there couldn't have been that necessary anxious scrutiny without that additional evidence. The phrase anxious scrutiny is taken from a number of cases, yes, and I refer simply to my skeleton argument where I've recited them from the various authorities, which is where Mrs Justice Laban has presumably got them because I apprehend she was a public lawyer herself and so very familiar with them. Accordingly, in my submission, my lord, the findings of the learned judge are unsafe and the court should allow the appeal and remit the case to a new judge for a fresh determination, again inviting, can't go any further than that, the official solicitor to represent AC as litigation friend at any such hearing.
I understand that's your ultimate objective, but you appreciate that our job today is very much more limited
Yes.
than that. Our job today is to identify whether any of the arguments that are raised are arguments that ought to be heard on a full appeal.
Of course, my lord. Understood. My lord, my lady, those are my submissions unless I can assist further.
Thank you very much indeed, Mr. Bogle. Mr. Guintervalli.
Yes, my lord, my lady. My learned friend has covered much of the ground I was planning to with regards to my first ground of appeal.
Well, in relation to matters that he's covered that you're content to rely upon, we'll assume, if you just say you do, that you do, but by all means put it better if you'd like to. But certainly there are matters that you distinctively raise for yourself under issues 3 and 4, which he's left to you to deal with.
The only issue I wanted to raise with regards to my first ground of appeal, so that's the issue of the procedural unfairness in these proceedings, relate, and this is issue I pick up on from paragraph 13 of my skeleton onwards, and this is the scope of CPR Rule 21.2.1 in relation to these cases. So that rule provides that a protected party must have a litigation friend to conduct proceedings on their behalf. And we've seen that the court does have power to disapply that rule to certain steps in the proceedings. But the submission that I'm making is that in these sorts of cases, in these life and death decisions, it's not that power to disapply the possibility of someone being represented at all is not open to the court, and that the court has obligations as a public authority.
So when you say not open, namely never, that should never be done in a case of this kind, you say?
No. Submission does go that far.
No.
The Article 6.1, the European Court has recognised, obliges state to provide legal representation to certain categories of cases.
Well, I think we've been here before, haven't we, that you don't have to start there. We've got law in this country.
I'm very mindful of...
Your essential submission, as I understand, is that it's, in a case of this sort, it's inevitably unfair.
Yes, it is unfair.
You then add European case law to it, but
the reason this time I do add the European case law is that one of the arguments which is raised against us is that there's a whole body of cases where simply people weren't made parties or weren't represented in these sort of cases, and that therefore the common law recognises this sort of procedure that was endorsed by the learned judge as being fair, essentially. I say that those first instance authorities shouldn't be taken as indicative of the law, but even if they are, Article 6 goes further and says that where the consequences are particularly serious, and I refer to the case of Timofeyev and Postupkin, unfortunately only in French, but the relevant paragraphs there are, which can be found on page 741 and 743 of the authorities bundle.
Yes.
Paragraphs 102 and 107 explain that where the effects of a decision that the court is making impact upon the human rights of the person involved, then there's an obligation, if they're particularly serious, to provide legal representation. And we say that in those circumstances, Article 6, quite apart from any common law duty of fairness, which is essentially the same, would oblige the party to be represented. I reserve my position. Perhaps I'd start here with the fifth point your lordship identified, which was how should these proceedings be, what's the appropriate way that these proceedings should follow. And I have certain sympathies for my learned friend's argument, which is essentially the one I ran in the Midrana Meat case at first instance. Upon reflection and with the passage of time and also other decisions, it does seem to me the case that it is open to the court to make declarations of death, and that there isn't anything in itself problematic with the court engaging in that exercise. But, and this is where I don't think there's any difference between my learned friend and myself, that in those cases where the court's considering making a declaration of death, that nonetheless the party has to be represented. And this it is an error which I respectfully suggest the learned judge fell into at paragraph 54 to 57 of the judgment, where he seemed to adopt a position where if it wasn't a best interest hearing, then there was no need to have representation. And my position would be it's open to a judge to make a declaration of death following an appropriate hearing. But during those proceedings, it's important that the party's represented. And the role of the party, and that's because until the declaration of death is made, there has to be a presumption that the person's alive. And that presumption doesn't exist if we accept, as the learned judge did, that the declarations of death made under the 2008 code have some sort of legal significance. And we simply say, and this will go into the second point, that they don't. It's evidence. It may be very, very strong evidence in certain cases, but it's simply evidence which the court seized of the matter and called upon to make a determination of death is going to have to weigh in the balance.
So
And
your position in relation to this particular issue is that and I apprehend, you're not going quite as far as Mr Bogle in saying that there has to be a best interests decision in every case. But what you are saying is that the person has to be represented in every case.
yes, because until the declaration of death is made
Sorry
by
to drop out. I didn't say in every case. I said in this case. I'm sorry if I cause out.
No, I may have. I may have put it wrong.
Thank you. Thank you.
But in any case, if neither of you are asserting in that case that there needs to be a best interests hearing in every case.
it's the point being, until the declaration of death is made by the court, and this is the important point, the diagnosis of death is made by the doctors under the 2008 code or otherwise, but that's a diagnosis of death. It doesn't have some sort of force of law, and this is the mistake, the conflation that I suggest that the judge fell into in treating that diagnosis as the confirmation. It isn't. The declaration of death is the function of the court. It's not the function of the doctor, and the court has to simply weigh up all the evidence before it and come to an appropriate conclusion. It may be that at the end of that exercise, there's enough uncertainty that the court will want to consider things to proceed on a best interest basis, or it may be that the evidence is so overwhelming, and I argue that the ground that has to be applied and which wasn't applied, the standard of proof is the criminal standard. If at the end of the exercise the court is convinced that is sure that the patient is dead, then the declaration is made, and there doesn't have to be a best interest exercise or investigation. But that doesn't mean that there's no role for the official solicitor up until that declaration is made. And that, in fact, was precisely the approach adopted in the Midra Namit case, which then became re-em in the Court of Appeal. The guardian represented, it was an action for a declaration of death, and this was in fact clear at all. Well, it was the position of the trust at all stages in those proceedings. The Kafkas guardian represented Midran Amik. But once the declaration had been made at the conclusion of the High Court proceedings, the guardian didn't cease to represent Midran Amik and didn't take part in the Court of Appeal hearing. And there was no criticism by the Court of Appeal in rem of that approach. Rem is a case which covered a lot of ground, and it keeps being cited, and I do agree with my learned friend that most of the time inappropriately cited, because it isn't in fact permitted to be cited, but it is cited nonetheless for all sorts of propositions. And but one of the propositions which is not being cited for, but which could be, is that there was no criticism of the approach in the Midran Amik case. Nothing we submit hinges on the fact that there was a Kafkas guardian with particular duties. The underlying principle isn't reliant on there being a different regulatory or statutory regime which the official solicitor would discharge, as opposed to that the guardian subject to. If I could just look very briefly at the Riem case, and that can be found at page 3.
Which of the grounds of appeal are you alighting on?
I'm moving on from my first ground onto my second.
Right, so according to our numbering, which one is that?
Yes, number 3.
Thank you. Right, so this is the legal test for death.
Yes.
Yes, thank you.
And it's page 6 of my skeleton. I'm looking at Riem later on in this discussion, but just as we were discussing it, I thought it would be, we could have a look at the case now. On page 374, it starts with the authorities bundle. What I want to look at is certainly look at start with the final paragraph, 113 on page 389, which is where the court directs that despite this being a permission hearing, that the judgment should be available for reporting and wider dissemination, given the importance of the issues raised and the fact that this is the first occasion that these matters have been ventilated at Court of Appeal level. And as my learned friend has pointed out, the practice direction is very clear that if a judgment is to be cited in court, a permission decision, then there has to be clearly expressly stated that there is a point of law that's being changed or being expanded, and that simply isn't there. But that doesn't mean that this judgment is not one which is of significance, because as the President pointed out, this was the first occasion that these matters had been ventilated. And I just wanted to look very, very quickly at a few of the points which don't change any law, but which are significant and which have come up in a number of cases since. The first is on paragraph 60, page 383 of the authorities bundle, where the court expresses a preference for a formulation in declaration of death cases that had been adopted by Mr Justice Hayden in Rie, as opposed to that adopted by court below in this case. And so that's an important indication which would justify this judgment being disseminated. Other important points towards the end of the judgment on page 388.
So, just to understand this, you say that paragraph 60 on its own would justify this being a citable authority?
Yes.
So what's the argument about then this being a citable authority? I mean,
Well, it's no point of law being expressed or extended, but it's making suggestions as to how.
yes, but you're about to rely upon certain parts of this case.
What I'm going to do is disavow those parts of the case which do purport to extend the law
Yes,
or to establish.
I understand that you may want to do that, but if on the narrow question of whether it should be a citable authority or not, the court said it should be.
Yes.
We're really concerned with the substance of the points that are being made, aren't we? Not whether it's citable or not, seeing as it's being cited by both parties, or all parties in this case.
Yes. The point is it's citable in as far as it's endorsing certain practical steps that should be taken in these sort of cases. But it's not citable in as much as it's purporting to establish a new principle of law or to extend existing law, because that falls outside the practice direction, and for reasons my learned friend has raises other issues, issues of constitutional significance relating to laws being changed without people having a chance to appeal them. But I can leave those other points then, but I'd identified 4 other points which were important, procedural points, not legal points within this judgment, including the fact, maybe I'll just mention this one, including the fact that paragraph 107, that these sort of cases are not pressing. So they're not the sort of cases, precisely because where someone's been presumed to be dead, there aren't any best interests. They're not the sort of cases which have to rush through the courts without giving people time to appoint experts or to prepare them properly. And so that it is appropriate in these sort of cases that the court steps down a gear and doesn't quite go as fast as it might otherwise do. But what this case is being relied upon is for the proposition that the Court of Appeal has endorsed brainstem death as a legal definition of death in the United Kingdom, and has endorsed, as Mr Justice MacDonald takes the test, he says that the court has to apply balance of probability when analysing the diagnosis of death under the 2008 code, and therefore can make a declaration of death as a result of that. And we say no, that's simply not something that REM can be used as authority for, and it's wrong. It's wrong because that statement itself relies upon an understanding of the Bland decision, which is incorrect, we say. And I've laid out, and I'm not going to go through it because it's all laid out there in clear detail, why their lordships and Bland simply weren't trying to establish a test of death. The only thing I may need to do, and is to correct some of the references which have got confused, I think.
Right, so we're talking about paragraphs 42 through to...
Yes, 42...
through to 53 or 54. 54.
54, yes.
Yes.
Fortunately, there are quite a few mistakes with the references, and I do apologise for that. It may be easier if I send a corrected skeleton. I just...
Well, don't worry about that, because when you say the references, do you mean the numberings?
Yes.
Yes. Well, I mean, it's a very familiar series of judgments, obviously. And if you've just given a warning, don't trust the numbers, then we won't do that. But we are here at a permission stage.
Yes.
And so we're likely to deal with the matter at a fairly high level.
The only passage I just want to have a very quick look at is on page 89 of the authorities bundle, because this is one that Mr Justice MacDonald also relies upon.
89?
89.
Thank you.
And it's the one I mentioned.
MacDonald is really taking what was said in Rem and virtually placing it in his judgment.
Yes.
I mean, they're all the same passages from the same members of the House of Lords.
Yes, but this judgment is this passage, Lord Brown Wilkinson says, and he says, "I have no doubt that it is for Parliament, not the court, to decide the broader issues which this case raises." And that's really the nub of this issue. A definition of death is not a matter for the courts. It's if there is to be one. And it's certainly not one that Parliament has entrusted to the medical profession. And it's one that the House of Lords was clear should be looked at by Parliament.
Well, I understand the criticism that you make, but I haven't yet understood what your remedy is. I mean, this was 30 years ago. Parliament has not defined death in the meantime, and an awful lot of people have died. Meanwhile, everybody has proceeded on the basis of the Royal College's approach for 50 years now. I appreciate that there may be room for debate about all of that, as about all important issues in which science plays a part. But I haven't gathered from the arguments that you've put as to what the alternative is.
In the vast majority of cases, there isn't any problem. There isn't a problem either because it's clear that someone is dead on any possible basis that the matter's looked at.
Yes.
Or if it isn't clear, in the great majority of those cases where there may be some doubt, the relatives or dispositions which the person themselves have left also.
Yes, but that leaves, I mean, we're here because this is not one of those cases which sincerely held views exist on both sides. And so what are you saying the answer is? I mean, people have to know whether somebody is alive or not.
Yes.
So what is the answer? If not what everybody has been doing for the last 50 years?
In a case like this, the court needs, where there is a dispute, and my learned friend for the official solicitor suggests that there's a growing number, or rather the official solicitor in making interventions before the High Court suggests that there are a growing number of such cases. There's certainly some cases, it's not a huge number of cases where these disputes arise, but where these disputes do arise, simply, and the court has seized of the matter, it has to follow a procedurally rigorous approach and will then make its decision looking at the evidence, all the evidence that's there,
yes,
as to whether someone's dead.
Applying what standard though? Applying what test? Because it, as you rightly said, is for the court to decide, and there will be evidence of all sorts before it. But how does the court decide? What is the test?
The starting point has to be the medical evidence, and one of the key issues is that of reversibility of the condition, so that if there's no prospect of any improvement in the person's situation, then that is a very strong indication that the person is in fact dead. And the code itself recognises this.
Yes.
It talks about...
That's part of the brainstem test calculus.
But it even goes a step further than that. And the code repeatedly points out that when the brain ceases to work, that the whole body begins to disintegrate. So it isn't a case that people can be kept in dead people can be kept on a stable condition for years on end. The code makes it quite clear that cardiac arrest will occur within a short time.
I think we're moving. I mean, we're really just trying to deal with the legal argument which exists here. But the point that I put to you is, if not the test which was applied by the judge and has been applied in many cases of a similar nature, what possible alternative is there? Because it seems to me at the moment that you're saying that where there is an impasse between doctors and families, one just simply shouldn't reach any conclusion at all.
Well, it may be that in certain cases, and my learned friend is correct in this, it may be that in certain cases a best interest approach does become appropriate. It would be a very simple balancing exercise where there's no hope of any recoverability. But the reason, and this is something that's hinted at by Mr Justice MacDonald, and also by Mr Justice Hayden, in the case involving the coronial law, which is that people have different concepts of death, and this is one of the realities. This is one of the realities of that the courts will have to confront. There are people who don't accept that that many religions don't accept that someone's dead if the heart's still continuing to beat. Yes. And so at that point in time, one of the considerations that the court would have to consider is whether the subject's Article 9 rights are involved at all. If someone doesn't accept...
It can't, I mean, whether somebody is a member of a particular religion or not doesn't affect the question of whether they're alive.
Well,
somebody who has a certain belief, somebody can't be alive because they have a certain belief, but dead because they don't.
Well, my lord,
you're mixing up, surely, Mr. Conrad, two different things. Of course, we're only here to understand what the legal test is for somebody being dead. What the legal test is may not accord with my idea of what being dead is, or your idea, or my lady's idea of what being dead is. But what are individual ideas of what being dead is? Don't tell us what the answer to the question with which the law is concerned with is, what the law considers to be the test.
In response to that suggestion, that, or rather to that observation that what someone believes can't determine whether or not someone's dead, my submission is that in fact the situation isn't that clear. In the absence of a statutory definition of death, it may be that the court does have to accommodate people's beliefs, and that was the case.
I'm afraid sometimes I would tell counsel they're pushing against an open door. Here I'm afraid you're pushing against a closed door, but I completely understand that what is in somebody's best interests may depend upon what their beliefs are. No difficulty with that at all. But that's a different matter to whether or not they're alive.
Well, my lord, I'm not going to push any further on that door, but all I will do is refer the court to the case of McKitty and Hayani from the Ontario Court of Appeal, which did wrestle with that question in the context of the Canadian Charter, and which did suggest, it held open the possibility that the courts would have to accommodate people's individual views in a situation where the Charter provided for this. And we would say that Article 9 similarly provides for those sorts of rights to be recognised. However, I push no further than that, but that's the only case that's dealt with this issue.
Right, and what's the page reference? I've got the...
That's page
report.
816.
Yes, and the reference that you want to rely on?
It's called McKitty and Hayani.
Yes, the page number.
I'm sorry.
I'm looking at paragraph 6, for example.
Let me just turn to it.
The adoption of a neurological criteria highlights a person's right to religious freedom.
It's paragraph 29.
Thank you.
It's a profound analysis in my respectful submission of the problems that face the courts in these sort of situations. And it should be said that in Ontario there was in fact a law which it's mentioned in paragraph 22, the Trillium Gift of Life Network Act, which provides in certain circumstances of organ transplantation that death shall be determined in accordance with accepted medical practice. So despite there being a law which does defer to medical practice, the court nonetheless felt that that the matter wasn't so simple where charter rights were at play.
That's not suggesting, paragraph 29 is not suggesting that you take into account the individual person's moral philosophy or religion. It's mixing all of those elements, isn't it? That the question, it's saying, is a question of justice informed by medical practice, bioethics, and moral philosophy in the general sense, not in the specific sense of the individual.
Yes.
And other disciplines.
That's true, but then if one carries on through that judgment, the next paragraph is dealing with accommodation of religious commitments, and the court does then go on to consider the issue. The problem for the appellants in that case was that Mrs. Takesha McKitty had died by the time these proceedings had come forward. So in the end, the court was able to say, well, look, the matter is moot, we don't have to decide it. But they did indicate that this was a problem, and it is one that might arise in a future case. It isn't one which arises in this case, because, and this is a significant point in a way relating back to ground one, or my ground one or ground two that your lordship had identified, and that's that no inquiry had been made, obviously, because the official solicitor hadn't accepted this role, but no inquiry had been made as to Andy Casey's own views of this subject, whether he accepted brainstem death as death or not, and whether that would have had any bearing on this matter. And that's the sort of issue which may have been helpful if Andy Casey had been properly litigated for the court to have explored, and it may have had a bearing on the decision which the court would have had to make. But I think I'll move on to my final ground, because which is the balance of the standard of proof grounds.
Yes.
Before I do, I do. Mr. Bogle did make the point, but I do want to underline it, that the paragraphs 34 and 35 of my skeleton just point out that the brainstem test has been found to be unreliable by the courts, and it's lordships will have to decide whether the evidence of Miss Roberts is admissible or not, or is admitted, but it's that evidence as well goes to the reliability of the brainstem test. I should say, with regards to grounds 2 and 3, and this was in the context of in the Battersby case, the Court of Appeal on these two grounds did give permission to appeal on these two grounds, along with various other grounds. We can see that on page 430 of the authorities bundle, where the first ground that was given permission on was that the judge was wrong not to apply the criminal rather than the civil standard of proof. And the second ground that permission was given on was that the judge was wrong to extend the common law definition of death to include brainstem death. Now, in the event, it wasn't necessary for the court to enter into any determination of those grounds or of most of the others, because it found that there was a more fundamental problem in the approach taken by the judge, so that those matters simply weren't dealt with. But since the Court of Appeal has already given permission on those two grounds, I do make the submission that it would be appropriate that the court did also grant permission on my grounds 2 and 3. The balance of probability ground, and this is one of those examples, as my lord pointed out, where the learned judge took a chunk of riem and incorporated into his judgment. But he says, at paragraph 50 of his judgment, that once the court is satisfied on the balance of probabilities that on the proper application of the 2008 Code of Practice, brainstem death has occurred, the task of the court, where a dispute arises, is to confirm the subject of the application is dead. And it's important to record that in Riem, there was no appeal, and it wasn't a matter of dispute that the standard civil standard applied, that the question was the balance of probability. So it wasn't, the court wasn't making a determination on that issue. The question only arose later in the Dance case, where it became one of our, when it became one of our grounds of submission, later ground of appeal. But in fact, this approach was incorrect. That where it did come to a weighty matter, such as this, and in line with various domestic authorities that recognize, and they're cited there in my skeleton argument. And again, I don't need to take the court to them. But the House of Lords and in the cases of B. Children and in the case of McCann and Manchester Crown Court had to look at the correct standard of proof to be applied in cases which were civil, but were cases in which there were particularly serious implications for the individual involved. And they said it was appropriate in those cases that the criminal standard should be adopted. So there isn't a rule that says that all civil cases are subject to the balance of probabilities. There's certain cases where the courts have recognized, and situations, it's respectfully submitted, which are far less serious to the rights under consideration in those cases than they are to Andy Casey's rights, that because the matter is so serious, that the criminal standard should be adopted. And there was a lot of, prior to these cases, there was a certain amount of confusion as to whether there should be some sort of special civil standard of proof that the courts would apply. But what the authorities have established is that there's one civil standard, but that nonetheless, in certain cases, it's appropriate for the criminal standard to be imported into the decision-making. And the submission here is simply that this is precisely one such case where a court has to proceed on the basis of beyond reasonable doubt in making a declaration of death. They can't possibly do that on the balance of probability standard, even on an anxious scrutiny basis. And so, to that extent, I depart from the arguments I'd advanced in Riem. But it's a necessary departure. And it's a necessary departure also as well in relation to the Strasbourg authorities. And there's a whole series of them. I've included just one, which is the case of Tagayeva and Russia. And at page 613 of the authorities bundle, that passage, which I've cited in my skeleton, can be found, which makes it clear that the beyond reasonable doubt standard should apply where there's a question that the court's involved in engages serious human rights issues. And obviously, the question as to whether the convention applies at all, whether someone's going to be beneficiary of any rights at all, is the most serious question that the court could possibly confront. Because if someone's found to be dead, then they don't enjoy any convention rights at all. So, just put briefly, in my submission, it's clear and necessitated, it's clear from the domestic authorities, but also necessitated from the Strasbourg authorities, that the question before the court has to be approached on a beyond reasonable doubt basis, so that the court is sure that the person is dead, not simply on a balance of probabilities. Now, I'm very, very mindful of my Lord's injunction and warning that he's not trying the case, but it may occur to the court to say, well, he may have applied the wrong standard, but we're simply, even if he had applied the correct standard, the criminal standard, he would have come to the same conclusion. And so I just want to take the court just one example to demonstrate why that wouldn't follow. And I'm not seeking to re-argue the case below, but just to illustrate one issue which arose and which may have led to the court to quite legitimately to make a declaration of death on the civil standard, but not if they had applied the criminal standard. And I would like to start by looking at the code itself, which can be found at page 965 of the authorities. The passage I'm looking at can be found at page 965 of the authorities preamble. And it's the last paragraph there. This is 5.3, exclusion of potentially reversible causes of apnea. The Lordships will recall that the brainstem test essentially has two parts to it. The first part is a series of what are called bedside tests, which are quite straightforward tests involving trying to elicit reactions from such acts as touching the cornea or pouring cold water into the air, which would it be expected to elicit a reaction if the neural connections between the sensory organs and the brain was still intact. The second part, and it's the final part of the test, which is always done once the subject has failed the bedside test, is the apnea test. And the apnea test is more complex, but essentially it involves disconnecting the patient from the ventilator and seeing if the patient will breathe or not, independently, because the idea is that once the CO2 levels rise in the body, that a breathing response is triggered. But there's a warning, and it's an important warning, page 965, which says, when coma follows a head injury, the presence of a cervical spine injury must be excluded in the usual way, using clinical criteria, plain X-rays, CT, MRI scans as indicated. If there are reasons to suspect that an underlying high cervical spine injury and associated cord injury are causing the apnea, then the apnea test, section 6.1.6, becomes invalid. In this rare scenario, cessation of brainstem function can be established only by confirming the absence of other brainstem reflexes and by using ancillary investigations. And this is quite controversial because this was an issue which figured very prominently in the Archie Battersby case, where various times the bedside tests were done and the problems weren't seen to be there. But the problems then related to whether the apnea test could be performed properly, because this peripheral nerve stimulation test, which is done on the body to see if there's any reaction, elicited no response in that case. But if I could take my lord and my lady to page C65 of the appeal bundle. This is, and I've just jumped in, this is witness statement of Dr. S. And
Yes.
And we can see there that paragraph 34 says, there was, however, extensive damage to Andy's spinal cord that was likely related to the process of coning, part of the cerebellum, brain tissue that would normally sit within the skull.
Yes, well, we see what's written there, but isn't this something that was subject to specific consideration in the form of further testing and in the form of further advice from neurosurgeons?
The problem is that what's been identified there is a contraindication to the apnea test being performed at all, quite regardless of whether there's further advice or not. And
so what's the conclusion? That if somebody is unfortunate enough to have an injury of this kind, you can't perform the brainstem test?
That was very much an issue that was,
Well, is that your submission?
if there's damage to the cervical cord such that it affects
I
the
understand that submission in that case.
the
In other words,
2000
you're saying that what happened here was that the test was performed, then it was queried whether the injury to the neck might have invalidated the results. That then was interrogated by other doctors who said no, it wouldn't. You say that that's an invalid process.
what we have is,
Well, I just want to know whether that's what your submission is.
my submission is that on its face, this is a case where the apnea test probably shouldn't have been performed, and where therefore a determination of death had to follow a different.
Right, and where do we find that in the hearing that was before the judge, in terms of evidence and reflection of the judgment?
So we find that at 34, paragraph 34 of the judgment,
Thank you.
citation reference to the other paragraph, which is 32, which is probably the one I should have taken the court to as well, which talks about the damage, which means that there's likely to be no functional pathway for signals to be transmitted to the chest. So again, if submission, this is a situation where even if the brain were functioning, there would still be likelihood that it wouldn't be able to control breathing because of damage to the chest. And that, incidentally, page 960 of the Code of Practice also deals with that situation and explains that people where the brain is functioning but have got, well, I think I don't need to rely on that passage, but it's the same principle as looked at there. It's very important to realize that the loss of breathing drive can only be determined where there isn't any damage to the spinal cord, which could otherwise impede it.
I follow the instance that you...
But the court looked at this matter, and it's of significance. And I certainly endorse my learned friend's ground one, which is a need to instruct an expert. But what is surprising in this case, in fact, is that there were no experts at all instructed, as far as I can see. There were a series of witnesses, witnesses of fact, essentially, who were supplied in various forms, who supplied evidence to the court. But there wasn't an investigation under these particular circumstances of these sort of difficulties, which an expert before the court, and even an independent expert, could have been questioned on and could have given the advice on. We understand there was, and he's not subject to the reporting restrictions mentioned in the judgment, Dr. Danbury, who had some sort of advisory role in the background. He may well have been a very suitable person to be instructed by the court to look at some of these issues, but not look at them in the background by means of notes and opinions, but looked at in the court, properly examined, and his evidence tested. Parents and also the official solicitor representing Andy being given an opportunity to test that evidence and to see whether, in fact, the damage to the cervical cord was likely to have invalidated the.
But Mr. Quindavale, as I understand it, Dr. Danbury was involved and suggested other tests that also be carried out, which were carried out. But it was never suggested, was it, that he should give expert evidence? That wasn't the position before the judge, was it?
As far as I'm aware, it wasn't the position before the judge. I wasn't present at the court.
I just want to make sure that I've understood that properly.
Yes.
But my submission is it could well have been very appropriate to have had him before the court. And the importance is, and it's understandable, in a lot of these cases, there simply isn't time to instruct experts and to follow the usual procedure of written questions being written and conferences being arranged to see if agreements can be reached, and if they're not, to instruct other experts. A lot of these cases are very fast-moving cases where the necessities of the individual's condition necessitates that the court makes use of what evidence it can, and that's available. This, again, as the Riem case shows, these sort of cases are different. There isn't that sort of urgency, and the President suggested it would be appropriate in those cases to allow parents to instruct an expert. It would also be appropriate, it's respectfully submitted, for the official solicitor to have instructed an expert, or for the court to have instructed Dr. Danbury to provide his input and to be able to answer those questions and to test his evidence, because it may be that he's totally correct in everything he says, but it may be that upon examination he turns out to be less certain than he might have appeared to be in the correspondence before the court.
Yes.
Just in terms of the sort of evidence that was the other sort of evidence before the court, and there was a fair amount of evidence, but the sort of evidence which weighed before the court, we see in paragraph 27 of Mr. Justice MacDonald's judgment. The Trust also sought second opinions from internal neurosurgical specialists, Dr. A and Dr. B, in respect of Mr. Casey's spinal injury. But then he says that the court only has clinical record recording this opinion. Again, it's a little bit troubling that and again, this is a feature understandably in many of these cases, but that witnesses of fact are being treated as witnesses of opinion, totally inappropriately. And it is my submission that this is a case where the conclusions that Mr. Justice MacDonald reached were probably acceptable if he had adopted a balance of probability approach, but simply the evidence before him and the doubts that must exist would not have allowed a determination of death if the criminal standard had been adopted in this case.
I understand.
I just one little point which I left out in the analysis of Bland, but important to make. My learned friend, Ms. Watson, cites a judgment of Mr. Justice McGarry, in which a distinction is made between obiter statements which are considered and those which are made completely off the cuff. And the suggestion is that Bland should be given great weight, the obiter statements that were made regarding brain death in those cases. My response to that is simply this, that since in Bland there was never any suggestion that Tony Bland was dead in any of the courts, and we can see this from the judgment of the High Court or the Court of Appeal, where they were very clear that all the experts would agree that he wasn't dead. So it simply wasn't an issue before the court. It wasn't an issue that was considered at all what constituted death. There were no experts on brain death in the court in Bland. Reflections were made, understandably, by their lordships, but they are totally obiter, and as such, they shouldn't carry much weight in resolving this very narrow question as to what definition of death the court should adopt. unless I can assist further.
Thank you very much, Mr. Wintervalley. Just give me a moment. We've overrun a little bit, but it's completely appropriate. It's a very, very important decision that the court is faced with. I'd like to thank counsel from whom we've so far heard for their submissions, and to thank everybody indeed for the attention that's been paid to the arguments that we've been hearing. Where we do appreciate that there are people present in court who care very, very deeply about the issue. What we're going to do is this: take some time to consider where we go with this hearing. An appropriate moment has arrived because of the lunch break. If we require, having given the matter consideration, to hear from the respondents, then we will return to court at 2 o'clock and do so. If we do not require to hear from the respondents, then my clerk will so inform you. So,
thank you very much.
If that is the case, then we will indicate a time later in the day at which we would give our decision and our reasons, but that is a matter yet to be decided after my lady and I have taken stock of where we've got to.
Thank you.
Thank you very much.
All rise if able.